Adler.
Thanks very much, and good morning, everybody. Mr. Balise, can you hear me, sir?
Yes, I can hear you. Am I coming through as well?
Yes, you are.
Okay, good.
And you understand you have 5 minutes, Mr. Balise, and we'll try to give you an alert when you've got about a minute left. So please go ahead.
All right. Well, in today's argument, and I am merely uh, asking the question in regards to my motion to vacate based on new evidence, and I'm assuming that everyone has had a chance to review that motion.
Yeah, we've reviewed the papers that you have filed. Yes.
Yes, okay. That's great. And with that, the evidence in question here is significant and it has the ability to significantly alter the outcome had it been available during the original decision. However, it was not available. My question to the court is, um, can this new evidence be considered in this case, and and if so, how?
Well, the trial judge, I think, decided that it was available before the hearing took place. Didn't the judge say that?
No, that was not the case. I don't believe that was the case. The the decision had already been made. The evidence had not was not available until late August of 2024.
All right. Have you got anything else?
No, that is it. The evidence basically is the certified medical documentation that the labor board had determined was the missing piece in supporting my testimony that my performance decline in the workplace was due to a decline in health. And in fact, that decline in health resulted in my being referred to a health organization as a candidate for a heart transplant.
Okay.
So
Anything
that
more?
no, there is no more. I mean, that this health decline was significant, and although the documentation wasn't readily available, all of the testing and all of the medical care that I was receiving during the time in which the employer was making the claim of misconduct and negligence. As a result, that evidence, although my testimony spoke of a decline in health as to the reasons in the workplace for my performance decline, the the certified medical documentation didn't exist at that time, and it wouldn't be available until late August, after that original decision had been made. By then, I was not able to have that information and that evidence considered. And once again, and I'm repeating now that on appeal, the board did finally indicate that that was the missing piece. Because my verbal testimony was not supported by that certified medical documentation, they upheld that decision
You
of
have 1 minute.
revision.
You have 1 minute, sir. You're free to reserve that.
And I reserve that
All right.
because I'm finished at this point.
Thank you. We'll turn to counsel for the appellee. Please start by introducing yourself, identify your client, and then proceed.
Thank you. Good morning, Your Honors. Jared Adler representing the Vermont Department of Labor. The decision of the Employment Security Board should be affirmed for three reasons. Mr. Balise's arguments this morning rely wholly on evidence that's not in the record, despite his opportunity to enter such evidence below at the proper stage. And even if this evidence was entered, this discharge does not meet the statutory standard for health separation. And finally, the evidence in the record does support a finding of disqualifying misconduct. So first, just looking at the evidence that Mr. Balise is seeking to remand the case for to have introduced, I disagree that it was not available below in a timely stage. The medical document that was attached to his motion here has a date of June 7th, 2024. And the initial determination in this case was made 10 days later on June 17th, 2024. So even if in that short intervening period it wasn't available, the evidentiary hearing before the administrative law judge, where Mr. Balise had the opportunity to enter any additional exhibits he so choose and support those exhibits with testimony, that was not until over 4 months later in October. The date was October 28th, 2024. So he had, approximately 4 months from when this medical appointment purportedly occurred until the evidentiary hearing when the ALJ would have accepted and entered additional exhibits into the record. So Mr. Balise did not try to enter those records at the proper stage and only now seeks to introduce them at this very late stage of the appeal. And even if those records were to be entered into evidence here, it could not transform this discharge into a health separation. And if we look at the statute, it's found at 21 VSA 1344A3, and I'll just quote from the statute here. It imposes a partial disqualification from benefits where, quote, the individual has left the employ of the individual's last employing unit without good cause attributable to the employing unit because of a health condition as certified by a healthcare provider that precludes the discharge of duties inherent in such employment. So in this case, there's no dispute that Mr. Balise was discharged from his employment by the employer. He did not voluntarily leave his employment. And so the text of the statute suggests that the individual, the employee, leaves employment because of their health condition, not that they were discharged, and that discharge has some component of health reason for the discharge. It specifically discusses an employee leaving employment, and I don't think there's any factual dispute here that Mr. Balise did not leave his employment. He was discharged for his performance deficiencies at work. And so finally, the evidence in the record clearly supports the board's decision finding disqualifying misconduct. Mr. Balise was placed on a probationary period by the employer in late 2023, and this is found at pages 36 to 41 of the appellate volume, for failing to communicate with his subordinates and properly manage their schedules. And so the employer placed him on a probationary period and began meeting with him biweekly to monitor his progress at work. Several months later, in March of 2024, the employer issued a written warning for—
You have 1 minute, counsel. You have 1 minute.
Thank you, Chief Justice. So the employer issued a written warning in March 2024 for additional issues at work, for failing to pick up youth clients that were serviced by the employer. And he was terminated 1 week later for failing to arrange job placements for youth clients served by the employer. And that was one of his chief job duties, was to secure placements for these individuals. So he was discharged for disregarding direct warnings that he had previously been warned about. And so the evidence in the record clearly supports the board's decision. And I'll rest my argument there and answer any questions the court may have. Thank you.
Okay, I see no hands, so thank you very much. Mr. Balise, let's find out how much time you've got. How much time is left, please?
Appellant has 49 seconds remaining.
Okay, Mr. Balise.
Yes. Well, and in response to Mr. Alder, I would simply say that the warning from the employer was not in late 2023. It was instead in March of 2024. That is when the initial letter of warning or correction would take place. In addition, the decision from a doctor, and I want to speak towards the decision that was or the appointment that I had with that doctor, and the availability of that evidence to me. That was not available until that August time period, simply because the doctor that I ended up that examined me and prescribed those tests left the system, and that doctor did not was not my assigned doctor. My assigned doctor was not able to see me that day, and due to that change in medical professional, I would not have access to, and it was not discovered until later that those records were improperly filed at the hospital.
Okay, your time has now expired. Please call a conclusion of the hearing.
The next hearing for the court